Good afternoon. A bit of housekeeping, please. Make sure you silence your cell phones. Thank you so much. All rise. Hear ye, hear ye. The Court of Appeals for the First District Court of Texas is now in session pursuant to adjournment. God save the Constitution and this honorable court.
Thank you all. Please be seated. Welcome to the First Court of Appeals. I am Justice Amy Guerra, and today we have Justice Andrew Johnson and Justice Kristen Guiney on the panel. We have one case on the docket this afternoon. Well, I guess there was one earlier with a different panel, but we'll say this is one case on the docket for this panel. Case number 012500 301 CV, Annettee Ramirez in her official capacity as the Harris County Tax Assessor Collector and Voter Registrar versus Steve Hotze, MD et al. May I have the announcements from counsel, please?
Yes, Your Honor. Christopher Garza and Eleanor Matheson with the Harris County Attorney's Office here on behalf of the Tax Assessor Collector and Voter Registrar, Annettee Ramirez.
Good morning or afternoon, Your Honor. Jared Woodcock for the appellees.
Thank you. All right, so each side will have 20 minutes for argument. Does the appellant wish to reserve any time for rebuttal?
Yes, Your Honor, if I may reserve 5 minutes.
5 minutes reserved. Very good. Before we begin, I'm sure you're all familiar with our clock and the colored lights you know that green means continue, yellow means you have 1 minute remaining, and red means to stop. If you're in between answering a question from the panel, then feel free to continue, and we will make sure to equalize the time if we go over for each party. And so obviously we've read the briefs, and it'd be most helpful if you all could just kind of dive into the legal issues, and we're ready to proceed with argument, starting with appellant.
Thank you, Your Honor. Good afternoon. May it please the court. This appeal turns on the meaning of address reclassification in the Texas Election Code. The trial court erred because there was a lack of standing and there was no waiver of immunity, but everything relates to that term. Every claim depends on it. And so what does that term mean? For 40 years, it is referred to the reclassification and renaming of roadways in Texas. As towns have grown into cities, farm-to-market roads are transferred into state highways. Highways might be absorbed into interstate systems, like when Highway 59 became I-69. Cities may rename streets, roadways, like when the city of Houston renamed parts of Dowling Street as Emancipation Avenue. Calhoun became MLK Boulevard. The reason that's important is because when that happens, the residents and businesses along those roadways, they don't move. The name was changed, but they didn't move. The U.S. Postal Service has to reclassify the addresses so that mail still arrives accurately and correctly. And that mail includes voter registration certificates. So just like the U.S. Postal Service must change their classifications, Texas election officials must do the same.
What authorities are you relying on for these statements?
First, Your Honor, from the code. Address reclassification is cited twice three times in the Texas Election Code in two different sections, 14.022 and 15.022. In both sections, it's about, in 14.022, it's about address, voter registrations going out and being returned erroneously. And when it's returned erroneously, you have to look at why. And one of the reasons in 14.022 is there's a address reclassification. When that happens, the voter registrar has to change its records. In 15.022, it's cited twice, both in A and B. In both instances, it relates to when the Postal Service is making a change in the addresses, and when it's a reclassification, the voter registrar has to correct its registration, and that includes removing people from the suspense list. And Your Honor, on that, we also have SOS guidance to the legislature in a 2005 committee hearing. The Secretary of State Election Department testified as a resource witness and said that's what this means, that it was codified in 1985. The term address change of address, Your Honor, was not added until 1995 in several areas in response to the National Voter Registration Act. And so the Secretary of State testified there that to that committee that that's the purpose of address reclassifications in the code. It's for a voter registrar to correct their records so that registrations get mailed out correctly. Continuing, Your Honor, this is also, again, the understanding of the SOS, and the reason the Secretary of State is important here is because the Secretary of State is the chief election officer in Texas. With statutory construction, as I believe this case is all dependent upon, agency deference is important. Again, Secretary of State, chief election officer, it also maintains the state's official registration list for the state of Texas. Just like all the other 254 counties, Harris County's registration is not in a vacuum. It is shared with all the other counties and specifically with the Secretary of State. The registrars in this state have a duty to send that information to the Secretary of State. The Secretary of State sends information back, and the Secretary of State monitors the compliance under Chapter 18 of the Texas Election Code. If, for example, the Harris County registrar was not doing what she was supposed to be doing, it's very clear that the Secretary of State would admonish her. There's penalties in the Chapter 18 of the Election Code, and that includes taking over Harris County's registration. That includes having the AG come in and rectify the situation. There has not been that here. There's no allegation of that here. So
Go ahead.
I can see that Your Honor wants to ask a question.
Well, I was going to ask you if this entire concept of the application or definition of address reclassification is possibly going too far into the merits when we're here on jurisdictional question.
That's a great question, and I know that was raised by the other side. And when it turns on, it's not merits in this instance, Your Honor, because, for example, in cases like the Houston Belt v. Terminal case and Texas Lottery Commission that are cited in the brief, when the issue turns on whether there is a violation as alleged here, the court must look to see, is there a violation? Have they properly alleged a violation? And so we have to see and look at the code. Could what they have alleged actually be a violation? If it's clear, it's black and white, and I know this case has shades of gray, the court must first determine whether or not there is a violation, because there has to be a violation for there to be harm for standing. There has to be a violation for there to be the adjunctive relief that the other side asked for under 273.081. There has to be harm there and a violation in the code. That's what the statute says. Moreover, there has to be a waiver of immunity because Harris County Registrar is a governmental entity. The only way to waive that immunity if there's been a clear and unambiguous waiver, such as an ultra-virus violation. For there to be an ultra-virus violation, the contours of the statute that's complained of must be examined.
So in other words, what you're saying is we're not really conducting a per se merits analysis into the statute, but as part of whether or not an ultra-virus claim has been asserted, we have to look at the statute.
That's exactly correct, Your Honor.
But if that statute is ambiguous, is that ambiguity enough to foreclose an ultra-virus
I think
claim?
Your Honor, if it's ambiguous, then we look at statutory construction and statutory interpretation. We look to see what it's defined in the code. It's not defined in the code, so we can't look there. Next step, we look at dictionaries, common terms, and we've supplied the dictionary definition in Webster's and Black's Law. It doesn't mean what appellees say it means. It means the recategorization and classifying. And so you use that term to modify address. And if that doesn't get us anywhere, we look at context. Under the presumption of consistent usage, we must assume that the legislature chose its words carefully, and when it chose to put address reclassification in 15022 and in 14022, that those words mean the same thing. When the legislature went back and added change of address to the same sections, like in 15022A, we must assume that they don't mean the same thing, because that would be redundant. And it would be an absurd result to have it twice. And so the court is in the position and the maybe enviable one of determining what address reclassification means before we can go further. And I don't think it's a merits base, because we're not getting into even whether or not I believe the registrar is doing it or is not doing it. We're just saying, have appellees allege something that could be a violation under the code and under the strictest sense. Moving on from that, Your Honors, again, we know what it means because, again, of the absurd results. We also know what it means because of the SOS guidance that we got in 2005. We also know, based on this statutory history, the term change of address, again, was not added until 1995, 10 years after address reclassification was first introduced into the code. We know that there have been several bills that tried to add it, and those were all rejected. We also know that it was added, again, to the first part of 15022. It was added to 15022A8. We also know that NCOA, the NCOA database that appellees allege change of address relates to and then transfers a duty upon the registrar. There's kind of two steps in that analysis. I would argue that you don't have to go to any of those steps, but to get there, They're saying that change of address means the same thing as address reclassification, and that provides a duty on the registrar to seek NCOA data. But the NCOA database was not even invented when the term address reclassification was added to the code. It can't mean that. It can't mean a database that did not yet exist.
Well, can't it, because it says specifically a request from the U.S. Postal Service, any available information? Well, wouldn't that include information that became available in the future?
If the sentence stopped there, as a period, Your Honor, I would agree with that analysis, but it actually says any information indicating address reclassification. So it's not any information. The term indicating address reclassification modifies the all available information. Again, that period being absent speaks volumes. The other reason we know this is because, again, in that same 2005 legislative hearing, the Secretary of State specifically said that registrars can do this if they want. They can look at it monthly if they want, but they don't have to. There's no duty there.
Is there a duty to monitor voter rolls some other way, somewhere else in the election code?
Yes. Yes, Your Honor. Specifically, and we can just stay on the NCOA for just 1 second, it was added in 2023 to the election code for the first time, and it was added and placed the duty only on the Secretary of State. None of the other 254 counties, and certainly not the registrar. So the Secretary of State does look at NCOA data, sends information back down, we send information back up. We also know that we have a duty under that section I was talking about, 14022, when it's every 2 years, we must send registration certificates out. When they get bounced back, the registrar then will put somebody on a suspense list because it's deemed that the address must not be accurate. We also look at change of address forms under Chapter 20 when someone applies for their driver's license, their DLs, when someone does any kind of governmental entity with the state, they compare the address that the voter has and sends that information to the Secretary of State. Again, this is not performed in a vacuum. Harris County doesn't have a moat around it where information is not transferred to the other counties, to the SOS and back down.
I have a question on a sort of
Sure.
different topic. What is, for purposes of our review of the trial court's denial of the plea to the jurisdiction, which is the live pleading that we're supposed to be looking at?
I'm sorry, Your Honor.
Which is the live pleading that we should be
The live
looking
pleading,
at?
the amended pleading, I believe, plaintiff's amended pleading is still a live pleading. It was incorporated into the reply in the PTJ, and we heard it at the PTJ hearing.
But it wasn't mentioned in the order denying the plea.
I'm assuming that the court made a mistake there. And I believe the other side will agree with me. We argued this case for about 2 hours at that hearing, and nobody objected to the amended pleading. I'm not going to object to the amended pleading, the live pleading that we're hearing about today. And that includes the word taxpayer or taxpayer standing put in there, and that includes the additional plaintiff, the Honorable Commissioner Sid Miller. I believe that does not hinge upon the outcome of the case because the claims are still the same. And so, Your Honors, this is a very wonky case. It's a lot of minutia. It's really a quite boring case, what 2 words mean in the entire election code. But everything hinges upon those 2 words, because if the appellees are right, then they have possibly been able to show harm, and we can come back on the merits or go down to the trial court and have a trial on the merits. They might be able to show a waiver of immunity. But as they cannot, because that term cannot mean that, they do not have harm because there's been no violation, then you cannot extrapolate harm from the absence of a violation. There also has not been a waiver of immunity, again, because there's no sufficient ultra vires claim that has been alleged. Your Honors, I think if you will look at, I forget which case it is, but you can't just say ultra vires and point to a statute and then that hauls the government into court. There still has to be an unambiguous, clear waiver, and we don't have that here.
Is it your contention that we can just resolve this entire case on immunity and don't have to get into the standing issues?
Yes, you could. Yes, you could, Your Honors, because you can look at either of those independently, but unlike the average private action, plaintiffs or appellees still have to show a waiver of immunity to bring the government into court. If they have not shown that clear and unambiguous waiver, then this case should stop. Okay, so I will reserve, well, there's 10 seconds left. I think I'll turn it over to the other side.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. For the past 15 minutes, you've basically heard a merits-based argument with respect to whether or not 15.022B applies in this particular case. As this court is well aware, the trial court denied the plea to the jurisdiction with respect to Ms. Ramirez. They granted the plea to the jurisdiction with respect to the county. This court is also very well aware that this particular analysis on this interlocutory appeal deals with one thing and one thing alone, not the merits of this case, but the underlying standing issues. And I think to better appreciate where we are with respect to standing, it's important to know who the four individuals are that were the plaintiffs or now the appellees in this case. One is Dr. Stephen Hotze, a taxpayer, a voter in Harris County, a registered voter in Harris County, someone who donates to campaigns. Secondly, we had a senatorial candidate, Joe Trahan, who was Republican nominee for SD 15, also resides in Harris County, a taxpayer, a registered voter in Harris County. Caroline Kane, another candidate, won the Republican nomination for Congressional District number 7. Again, is a taxpayer living in Harris County and was the nominee going into the 2024 election. And finally, we have a statewide elected official in Sid Miller, the agriculture commissioner, who's going to be on the ballot going into 2026 and that he's already filed. So I think that's important because each of these individuals have a direct or particularized injury with respect to Ms. Ramirez not interpreting or doing her job under 15.022B. And one of the questions that I think was insightful that the trial court asked Mr. Garza during the hearing on the plea to the jurisdiction is, who would have standing? If a candidate doesn't have standing, a taxpayer doesn't have standing, a registered voter doesn't have standing, and an elected official doesn't have standing, who would have standing? And the answer was, couldn't give you. He couldn't name anyone. So the trial court gravitated to the fact that under the county's position, no one would have the ability to challenge 15.022B and its interpretation that the county has put in place right now. So I think that's extremely important because when you go and you look at a case like Bloom versus Lanier. Bloom versus Lanier was a case where Mr. Bloom, Ed Bloom, was attempting to amend the city charter. And so there was a petition, and it was signed by a whole lot of people. Mr. Bloom was one of the individuals that signed that petition. And so there was a charter amendment that was supposed to be put before the voters. The problem is the language that was put before the voters was different than that was part of the petition itself. And one of the things that Mayor Lanier at the time argued that was Mr. Bloom did not have standing because he was part of a larger group of individuals, a larger population of individuals that signed the petition. Well, trial court agreed with the city in that particular case. So did the First Court of Appeals. But the Supreme Court, Justice Phillips, writing for the majority, said no, that was enough. That because he actually signed the petition and was part of this subset of individuals, he had a particularized and unique injury that afforded him standing. So first and foremost, I think we have direct standing for each one of these individuals. Secondly, if you look at the election code, we cite it very clearly. And I think this is very important because there's a specific provision in the Texas election code that you'll find at 273.081, where it expressly provides, and I'm quoting, a person who is being harmed or is in danger of being harmed by a violation or threatened violation of this code is entitled to appropriate injunctive relief to prevent the violation from continuing or occurring. So the Texas election code specifically lays out a provision relating to injunctive relief when an individual believes that the body administering the election, or the individual here, Ms. Ramirez, is violating the code or is threatening to violate the code. Now, they're going to argue, as they argued in their brief, a case called Andrade versus NAACP. Now, what's interesting about that case is the judge, Jefferson, I believe it was, did a two-prong analysis. He first looked at the provision in the election code to see if it expressly conferred and it alone conferred standing. He said no, that alone did not confer standing, but you also had to have the particularized injury that each of our four plaintiffs or appellees have in this particular case.
Which is essentially vote dilution, right?
Yes, absolutely. So to the extent that the county in this case has attempted to distinguish 273.081 based on standing, I think if you read further into the case, you'll see we satisfy the requirements that the Texas Supreme Court articulated in that particular case, in that our injuries are unique. So I think that's important for the court to appreciate that. Then finally, Judge, or not finally, but next, there's taxpayer standings. There's a whole host of case law that says when taxpayer funds are being used inappropriately.
How are they being used inappropriately here?
Well,
the election would have happened anyway.
Sure, but to the extent that people within the taxpayer's office are not doing what they're supposed to be doing, those are our funds. Those are taxpayer funds, meaning the residents of Harris County. So this is unique to Harris County. So obviously we have 254 counties across the state of Texas. Harris County has taken, we believe, an approach that's different than other counties and interpreted 15.022B differently. And so that's where we are. That's why we filed a request for declaratory relief. It's a declaratory judgment because we believe there is uncertainty with respect to how this statute should be interpreted. And I think you've heard Mr. Garza's argument. I think he made it very clear that with respect to reclassification itself, it's not even defined in the Texas Election Code. And as Justice Johnson, you pointed out too, there's some very broad language in 15.022B, which starts by saying any available information indicating address reclassification. Any available information. It's our position that includes national change of address. Well, what is the national change of address list? You may already know exactly what that is, but that is put together. The United States Postal Service uses it. And so when an individual is moving, there are two portions of it that you can fill out. One saying, I'm only going to be gone for 6 months or less. Check one box. If you're going to be gone for 6 months or longer, then you check another box. Our position is the statute requires the tax assessor collector, or here at the voter registrar, to take the NCOA database on a monthly basis, bounce it up against the voter registration file, and when you have a hit showing that that individual has moved, then you send them or you put them on a suspense list. That doesn't mean that they can't vote. All that means is when they come to that polling location, there's an S next to their name. They then fill out what's called a statement of residence or an SOR, saying this is me, this is where I live, or if they have moved, they identify that in the statement of residence. So we're not asking that these people not be allowed to vote. We're asking that the law be followed in that as a result of hits found based on the national change of address list, that they be put on the suspense list.
Well, let me kind of stop you for a second.
Yes, sir.
And tell you, there's a lot of different trails on this case, there's a lot of different issues. Where we're at, we started talking about standing. My understanding is what you're talking about at this point maybe goes toward the immunity, because not only do you have to show standing, but you're also going to have to show a waiver of governmental immunity here. My understanding from reading the briefing and the petition is the argument is made there is a waiver of governmental immunity here because there's an ultra vires act, and that ultra vires act is that the registrar is not complying with 15.022. Your argument is she has a purely ministerial duty to monthly check the NCOA database, and she's not doing that, therefore she's acting ultra vires. Am I correct in that's your argument?
That is absolutely correct, Your Honor. On top of that, we pled Texas Civil Practice and Remedy Code Chapter 37, the Uniform Declaratory Judgment Act. So as you know, that also brings it to play with respect to the underlying immunity issue. So if there's controversy or uncertainty in a statute, then courts have the ability to go and determine or resolve that controversy or that uncertainty. And we believe that essentially the county is putting the cart before the horse at this point in time, because all we're dealing with right now is a plea of jurisdiction. Ultimately, we may very well be in front of this court, depending on how the trial court, Judge Garrison, rules on the underlying deck action and whether that is correct or not. But right now,
I want to make sure that we understand it when we draft this opinion, is when we get to our immunity section of the opinion, there's two arguments why there's a waiver of governmental immunity, and that's purely ministerial act, they're not complying with 15.0022, they should be checking the NCOA database monthly and the declaratory judgment, chapter 37.
That's correct, Your Honor.
Okay.
All right, I have a separate question about the parties. So we noticed that the prior tax assessor collector, Ms. Bennett, was named in the original petition, and Ms. Ramirez was not named in the later petition, but we noticed in your brief, in your brief you say that Ms. Ramirez was automatically substituted per Texas Rule of Appellate Procedure 7.2, but that does not really take care of what happened in the trial court. So what's your response to that?
So effectively, the county, and I think they would concede this, is taking the same position with Ms. Ramirez that they had under Ms. Bennett, that they are not required under 15.022B to balance the national change of address list up against the voter registrar list. So I think that is the current position they have right now. Regardless, I still think the uncertainty with respect to the application of the statute is something that needs to be decided by ultimately a trial court, this court, or the Texas Supreme Court. As this court may very well be aware, a group of legislatures and state senators and other local officials have filed an amicus brief in support of our position in this particular case. So I think that there clearly is an issue that needs to be resolved by a court to let folks know exactly what this particular statutory provision means.
Yes, and I'm aware of the letter that was filed. I guess what I'm talking about, though, is the proper party being named in the trial court, and there not having been, change, an amendment to add the current, the then current and now current tax assessor collector.
Sure. My understanding is that occurred after the lawsuit was filed and after the court had ruled on the plea to the jurisdiction. I think both parties concede and would stipulate that Ms. Ramirez would now be the appropriate party in that she's the duly elected tax collector. Obviously, there was an election in the interim while this case was pending. Ms. Bennett stepped down, chose not to run. Ms. Ramirez was then elected. And then I just finally, Judge, Your Honors, a couple of other issues that I think are important for this court to be aware of with respect to the mootness issue. Obviously, we don't believe that this issue is moot because it is obviously capable of repetition before the case could be adjudicated. There is obviously an exception to the mootness rule. When a case cannot be fully adjudicated before an election, before the event occurs, then that exception applies. And so to the extent that the county I don't know that the county is necessarily going to take that position, and I didn't necessarily see it raised in their brief, but we don't believe that the issue is moot because the county's position is that 15.022B does not apply in this particular case.
What is your argument for why we should read address reclassification differently from change of address when the legislature clearly used those terms separately?
Well, address reclassification is not defined anywhere in the statute. Even in the provisions that he cited, they do not define address reclassification. It's not defined anywhere in the Texas Election Code. And so that's one of the reasons we're here asking for a clarification, or we're at the trial court asking for a clarification as to what that term means and whether
Don't
or
you
not...
think the legislature would have used the phrase change of address if they meant for address reclassification
Well,
to
I think,
mean that?
sure, I think address reclassification can be referred to as a change of address, meaning your address is reclassified or changed. That's a very broad and general term. If you look at our brief, Your Honor, specifically, beginning on page 51, we go through a whole series of interpretations as to why the meaning that we argue should be adopted is appropriate, and we see that on page 51, 52, 53, 54, and 55 of the brief. But again, we get back to the whole point where obviously the two sides disagree on what this statute means. And that is the whole purpose behind the declaratory judgment, for a court to look at a statute and determine or make a pronouncement as to what it means, and then for a higher court to determine whether or not the trial court got it right. Here, we are at the first stage of that juncture, whether or not these individuals have standing and can move forward with the ultimate issue or the ultimate question as to whether or not what the statute means, and to declare under the Declaratory Judgment Act what the statute itself means. Thank you.
Thank you.
Your Honors, just a few things real quick, if I may. It's going to be like a shotgun blast very fast. But the 4 individuals, candidate, voter status, the Supreme Court has said that alone does not confer standing in Andrade v. NAACP. It's a brief citing the statute. That same case says that 273.081 does not confer standing. You have to have standing first, then injunctive relief. It authorizes injunctive relief if you can show harm, again, a standing element, and a violation of the code. Neither of those things are here. The taxpayer standing, in the pleadings, they just throw out taxpayer one time. Under Andrade v. Venable, you have to show that there's been more than a de minimis amount of funds spent on an activity that would not be done otherwise. Justice Guiney, you mentioned that the election would occur anyway. The registrar would be doing voter rolls anyway. That case, Andrade v. Venable, shows that you have to show that they're doing something illegal that is not just the cost and time for government salaries being paid to perform their normal duties.
All right, but in the universe of all the hypotheticals, what is the answer to Mr. Woodfield's question? Who can challenge?
That's perfect. And you still have to show harm. If you can show harm in some way, then I think you clearly get past the standing hurdle. There's still a waiver of immunity issue, but if you can show particularized harm, like Heckman v. Williams, you have to show particularized harm. It's not hypothetical. It's not speculation. In the Andrade case that Mr. Woodfield mentioned, that it was Justice Brown, went through 2 different analyses. There was the standing for an equal protection claim, which the voters had, because some voters in one county were being treated differently than other voters in that same county. We don't have that here. This is the quintessential generalized grievance where they're just pointing to a statute saying, violation, prove us wrong, and we have standing. That doesn't carry the day under the standing purposes. Real quickly, 37.006 of the CPRC, the DEC action, that is not a clear waiver of immunity. That's only for when you're questioning the validity of a statute. It's not a government official's actions under that statute. That's the El Paso case, the city of El Paso v. Heinrich, and it very clearly says DEC action is not appropriate for when you're complaining of a government's actions based on the statute. You have to be complaining about the statute itself. As for the statute, there's 2 reasons why the definition that Mr. Woodfield wants you to use are absurd and can't be used. The first one, is as cited in the brief, there's SOS guidance that every 2 years there's a 90-day moratorium on making broad changes to the registration rules. So that means that every 2 years, 90 days, twice, once in the primary and once from the general election, you can't do monthly changes like he's asking. That would be an absurd result if every 2 years, for 6 months of those monthly reports you're supposed to get, you can't use them. That doesn't make any sense. Again, that's a national voter national voter registration, and the other side actually quotes that in their brief as well. So if it meant what they say it means, then you couldn't do monthly, again, for 6 months out of every 2 years. Second, if you look at 14.0.
So is there a contention then for a certain amount of time every election cycle, this monthly requirement doesn't apply?
No, that you still do, because it's not taking people off of the voter rolls. It's not negatively penalizing them. That moratorium is only removing people from the voter rolls. It doesn't say you can't make clerical changes. You can't make sure that mail is getting out to someone, but you can't take them off a voter roll. And if you look at 14.022, the section that talks about address reclassification, it says if a registrar determines that the voter's renewal certificate was returned delivered solely because of postal error, address reclassification, or clerical error, the registrar shall delete the voter's name from the suspense list. If we use the appellee's definition there, if we use change of address, it would be saying if there's a change of address, you remove someone from the suspense list. That's the opposite of what they're asking. So they're saying in 15.022, it means change of address. In 14.022, it doesn't mean change of address because that would be the opposite of what we ask. That is an absurd result, and that's why this court must review the statute and come up with the interpretation of what address reclassification means. And with that, Your Honor, I would ask that you reverse and render judgment on behalf of the voter registrar.
Thank you both. We have your arguments, cases submitted, and this court is adjourned for today.
All rise.